Yeah, we are live now.
Good afternoon, sir, and a very good afternoon to all our viewers. Today, we have Mr. Lakshmi says S. Kamath, sir, as our honorable guest speaker. Let me introduce him to our viewers. He is an advocate on record at the Honorable Supreme Court. He has done his LLM from the SOAS University of London, and he has also practiced as an advocate in the chambers of Mr. Gopal Subramanian, Senior Advocate and former Solicitor General. Sir was also a Senior Associate at Agarwal Law Associates, and he is an instrumental in arguing several important cases. He is now predominantly handling matters before the Supreme Court, Delhi High Court, and the Telecom Dispute Settlement and Appellate Tribunal, and also the Appellate Tribunal for Electricity, Competition Commission, and National Consumer Dispute Resolution Commission. So now I would request Mr. Jyoti Prakash Datta to take the event forward.
Thank you, Pragati, for the introduction of our honorable guest speaker. So, before we start with the session, I would like to welcome all the participants here. It is the fourth edition of our national webinar series. Previously, we have hosted several dignitaries like Justice Sanjeev Kumar Panigrahi of Odisha High Court, and secondly, we have also hosted Mr. Ashok Kumar Sharma, Senior Advocate, Supreme Court of India, and we have also hosted uh, Mr. Subhash Chandra Agrawal, eminent RTA activist. So, in this edition of our webinar series, we are going to host another eminent advocate as introduced by our team member Pragati, Mr. Lakshmi says Kamath. He is advocate on record. So, without losing any time, I will introduce you all to the theme of our discussion. So, today we are going to discuss about three things predominantly. So first theme is about the art of advocacy. What the essential arts that we require to be an effective advocate. And the second is the approach to read law, how to read statutes and case laws effectively. And thirdly, as sir is also an advocate on record, so he will also enlighten us something about the procedure, how to be an advocate on record, what is the examination procedure, and what is the role of an advocate on record. So, without losing any more time, I would request sir to take over this session and enlighten us with his intellect and knowledge. Please, sir.
Good afternoon, everyone. Firstly, I should say it's a commendable effort by Lex Cognoscenti for the reason that, education knowledge is always supposed to be spread. Now, especially I figured a lot of people don't have mentors enough who are first generation lawyers, who don't have good mentors to actually help them come forward. So I think the effort taken by your association is just fantastic. I think it's really commendable to that extent. Now, secondly, Jyoti was very kind enough to say I'm an eminent lawyer. I think we are all struggling lawyers, upcoming lawyers right now. So I'm still not reached the eminent yet, but yes, the endeavor will be always to reach there. Now, I would be discussing on three topics today. One is on the skills required. Second is how to read, understand law. And third is the role of advocate on records on the Supreme Court. Now, to begin with, it is very important that a student of law, including the lawyers, always remain as a student. Because the moment you think you are aware of the entire law, then your thought process stops completely. So it is very important that, am I audible? Jyoti, am I audible? Okay.
Yes, sir, you were audible, sir.
Sorry, yeah. So if you can just start and groundwork for preparation of a case, because a lot of queries had come to me as how to read law and how to prepare a case. So my endeavor today on the first aspect of law would be on this area. Now, if you can go to the next slide, please. Like I said, Martin Palmer has said, the secret of mastery in any field is to be forever a student. This is for the reason, like I initially mentioned, if you think that you are aware of the entire law, we don't tend to read it again. But each time you read law, there is some mystery attached to it. You come up with something new or you get a different angle to it. So therefore, my suggestion would be to read an enactment each time you're working on it or handling a case. Next slide, please. Now, what takes to be a good lawyer? One needs to have passion in any area of subject one wants to endeavor in. Second is perseverance. Nothing comes without hard work. Now, you might wonder why is patience required for a lawyer? Now, as you're all aware, we can't reach eminence or greatness on the very first day we start practicing law. It's an uphill task. It's a high climb upstairs. For that particular reason, you'll need patience, sufficient patience, so that all your effort is rewarded in future. Lot of young, very capable lawyers, they lose midway for the reason they think they're not rewarded enough. One thing which all student of law should understand is the rewards will be granted to you. You'll achieve it all in future, not in presence. Therefore, patience to actually achieve success is very much required in this law and this subject. A lawyer also needs analytical skills. He has to analyze law, he has to analyze facts. He needs research skills. Why is research important? Because when a client comes to you, he gives you certain facts. You have to look for law which is best applicable to your particular facts. So therefore, research skills are very much required. And as students, all of you, I'm sure, during your internship are actually asked to do a lot of research. Writing skill is also very important, probably the most important factor for a lawyer. Why is writing skill important? Because writing is where your foundation of the case lies. A bad draft without taking proper points or this one would actually defeat your entire case. So therefore, it is very important that you have good writing skills. And the only way to improve it is by writing and drafting. You have no other shortcut. One can't teach one any drafting skill as such. But there can be certain guidelines on how writing of how a plaint or a suit should be drafted. And lastly, communication skills. As a lawyer, we communicate through writings and through oral submissions. For both these reasons, all these skills are very important. Next slide, please. Now, law would probably have been boring if it was a mathematical formula. For 2 + 2 is always 4 in maths. But in law evolves, law changes. The interpretation of the Supreme Court keeps changing. So that is the reason why law is a perception. So there is always the scope for having a different view. Assuming there is a judgment which covers us on a particular point, we can always go back to the court and say probably the earlier decision of yours is wrong. It needs reappreciation. It needs to be looked into fresh on certain circumstances. For that reason, law is always, like I said, it's a mystery. You can never give up. You can keep working to achieve what you want. Now, just to take an example, you're all aware of Keshavananda Bharati case, the fundamental rights case. Now, what did the Supreme Court hold in Shankari Prasad versus Union of India? They said initially that Parliament have absolute right to amend fundamental rights of the Constitution. This was followed by a 7-judge bench in Sajjan Singh case. I.C. Golaknath in 1967 took a completely different view, saying, sorry, you can't touch fundamental rights at all. Parliament has no power to touch fundamental rights. And in Keshavananda Bharati case, what the Supreme Court held is, no, fundamental rights can be amended, but the amendment cannot touch the basic structure of the Constitution. So these 4 judgments give different perspective over different period of time. So the point which I'm trying to make here is that you can always differ with a view taken by the Supreme Court. And you can always try to change it depending on the circumstances or for certain reasons. So you can always come up with a different view. And so you can always have this never give up attitude. That is the reason why Supreme Court, a larger bench in future, sometimes says, oh, sorry, the earlier judgment is wrong. So therefore, we are overruling it. This is what happens. So therefore, no matter which case you get, always apply a fresh mind to it, give it a fresh leaf of life, so you can go forward and make your argument without any fear of being struck down. Next, please. Now, this is very important for law students as well as for lawyers. We all have this tendency in college as well as when you become a lawyer, that the moment you work on a case, we go straight away to commentaries or some writings or guides. But we miss the fundamental when we do that. Now, what is the fundamental of law? The fundamental of law is the enactment. It's the bare act. It's the bare provision which one needs to read before one proceeds on any way. Next, please. Now, if you can all just take a minute or say 30 seconds to understand the difference between, there's a fundamental difference in Article 19 and 21 of the Constitution. I've just extracted it on this, and which you can see on the screen. So if you can just take 30 seconds to read what is the fundamental difference in Article 19 and 21. I'm just giving you 30 seconds here. I suppose everyone would have read. Anyways, we can move to the next slide. The fundamental difference is, if you see Article 19, it talks about protection of certain rights regarding freedom of speech, etc. Now 19.1 starts with words all citizens. Article 21 starts with the word no person shall be deprived. So there's a difference between citizens and no person. Now, if you can just come to the next slide. Now, just see carefully how we break down Article 21. It says no person shall be deprived of his life or personal liberty except according to procedure established by law. So I have split Article 21 into 5 different parts, each having different and very strong meaning. Now, if you can just come to the next slide. Now, no person in Article 21 would mean all people, whether citizens or aliens. Shall be, it's the word uses shall and not may. There is no discretion given to the state. So if a person is deprived of his life or liberty, it can be and shall be only by procedure established by law. Now, what is procedure established by law? It means there should be a law or a procedure prescribing how a person can be deprived of his life or liberty. So you would have realized that the word used in Article 19 is citizen and not person. But in Article 21, it's person. So Article 21 has a larger scope. Now that is the reason why, for example, just to take a case, Ajmal Kasab, who was a terrorist who was caught in Mumbai during the terrorist attack 26/11, was given a fair trial, because the fair trial is eligible any person, whether it is a terrorist or any person or a citizen or an alien, is eligible and entitled for fair trial. That is the reason why his life, that is no person, right? So a terrorist's life was also taken away only by procedure established by law. Everyone kept asking, why should we give him a trial? We should just hang him, or we should just get him off. That's what everyone kept saying. But we are bound by the constitution of the country, which says a person can be deprived of his life and liberty only by procedure established by law. Assuming Article 21, the word used was not citizen, not person, but citizens, then probably, yes, we could have had a different interpretation to Article 21. but not as long as the word used is people, no person. Next slide, please. Now, what is procedure established by law? Now, our founding fathers used the word procedure established by law in Article 21 because they didn't want interference by the judiciary while deciding certain policy taking. Now, what happened? The Supreme Court, over the period, has expanded the scope of procedure established by law to due process of law. So, what does procedure established by law mean? Procedure established by law would mean a person can be deprived of his life if a particular XYZ procedure is laid down. Now, in India, a person is deprived of his life by hanging him to death. So the procedure laid down is one goes to the trial, and after the trial, after he's assumed his appellate rights, then that person would be hanged to death. Now, assuming the procedure prescribed that a person can be put to death by stoning, whether that would be reasonable or not. Now, if Article 21 remained as it is, as per the interpretation of the Supreme Court, then the state could have prescribed any procedural law for him to be put to death. But through evolution of law, by expansive interpretation by the Supreme Court, the court held that a law should be reasonable. And where do we get this word reasonable from? It is derived from Article 19, reasonable restrictions, if you remember, and should not be arbitrary. Now, where did you get word arbitrary from? That is evolution from Article 14 of the Constitution. So therefore, the Supreme Court held subsequently that any virus of law, even which takes away right to life, can be deprived only by facing two tests. That is 14, 21, and 19. 3 articles. So it's important that the procedural law is also upheld as well as the substantive law. So due process would mean that both substantive law and procedural law will have to stand the test of the Constitution. Next, please. Now, if I'm sure you would have all have learned Constitution in your school, college. Probably, I'm not sure if there are first year or second years who are viewing this, but otherwise, A.K. Gopalan's case would be familiar to all of you. Now, in A.K. Gopalan case, the issue was with regard to preventive detention, whether that would infringe someone's Article 19 and 21. The majority held that Article 19 has no application to laws depriving a person of his life and liberty under 21 and or Article 22. This is what A.K. Gopalan said. However, there was a minority view which said no. Article 22, 21 should all be read together. That was Justice Fasil Ali who has held that in the minority view of A.K. Gopalan case. That was in 1950. Now, what happened after 20 years? Now, in R.C. Cooper versus Union of India, which is popularly known as the bank nationalization case, Supreme Court held no. Fundamental rights cannot be put as separate watertight compartments. They have to be linked with each other. They have to be analyzed with each other. And it can't be put separately or decided separately. So, for example, if I'm detained, the procedure will also have to be tested, just to give you an example. Now, this scope was even widened in Maneka Gandhi's case, where it held that law depriving a person of personal liberty has not only to stand the test of Article 21, but it must stand the test of Article 19 and 21 of the Constitution. Now, just rewind till 1950. Assuming everyone believed, oh, A.K. Gopalan case covers us, then there wouldn't have been any evolution of law which led to Maneka Gandhi's case. Next slide, please. Now, you have already seen the aspect of how to read a law. So just to reiterate again, you'll have to read a particular provision word by word. You can't simply skip any word at all. Each word will have a meaning and a counter to a particular facts or otherwise. So it is very important that you read a statutory provision very clearly, break it down like in the example I had shown earlier, that no person shall be deprived of his life or liberty except by procedure established by law. So any provision which you read, pull out a bare act, no matter which subject you are being taught or which law you are handling. Your first endeavor always should be to take the bare act, to read the provision word by word. I'm not even saying sentence by sentence. It should be read word by word. Each word will have a meaning. It may be defined, it may not be defined. So that is how you read law. You can't simply go straight to a commentary or straight to guide and just start reading on what the subject is. By doing that, it's like a blind person. You're describing something to a blind person, and that blind person is not able to perceive what you're saying. For example, a blind person would not have seen color yellow. You may be trying to describe him saying it's a bright color, it's not orange, but it's near orange, it's not red, etc., etc., etc. So he won't understand or discern the color unless he can see it. It's the same with law. If you are doing a mistake of straight away going to a particular commentary or a textbook, then you are losing the essence of the legal term. You're losing the essence of the act. Now, probably, I'm not sure, most of you wouldn't have probably, I'm just putting a caveat there, wouldn't have differentiated between no person and citizens. So the point here is to give emphasis on each word. I'm just saying this for repetitive sake so that you all understand, and it just stays there every time you read a legal provision. Now, one other skill what a lawyer needs is to frame a question properly. A lawyer can frame a question properly if he understands the law first. Without understanding law, if you have to frame a question, that may be counterproductive or it can have different inference. Now, take for example this particular question. The question is it legal to cause death of or kill XYZ? What would be everyone's answer? Next slide, please. Now look at this particular question. Is it legal to murder XYZ? Can we just go back to the previous question, please? Previous slide, yeah. Just for repetition's sake, just analyze this question as well as the next. Is it legal to cause death of or kill XYZ? And the next slide, please. Is it legal to murder XYZ? I'm talking about humans. I'm not talking about any animals here. Next slide, please. Now, just for a second, see section 299 of IPC and section 300. It defines what culpable homicide is and defines what murder is. Now, for culpable homicide and murder, there should be an intention of causing death. Next, please. Now just look at section 96 and section 100 of IPC. Section 96 says nothing is an offense which is done in the exercise of the right of private defense. Now section 100 says when the right of private defense of body extends to causing death. So there are exceptions given in section 196 in where you can cause death of someone in private defense. Now there are 6 categories given here in cases where you can cause death of someone while you try to defend yourself. Next slide, please. Now just look at these 2 questions. Now I think you might have an answer or a different answer to both the questions. Is it legal to cause death of or kill XYZ? And is it legal to murder XYZ? The answer to first one would be section 96 and 100, right? Because you can do it in self-defense. You can cause death in self-defense. But is it legal to murder someone? No, it is not. because in murder you have an intention to kill. So each word which you use in your arguments or in your draft or the way you frame is very important in advocacy. So my endeavor here was to show you, this is just an example, just to show you that it is very important that you use the correct words and very consciously. So as young lawyers or law students, I think you should get into the habit of choosing the words very wisely and carefully, for which it is important for you to read the law before. Now, a person who is not aware of this particular case, assuming a question is put in the during the cross-examination scene, did you murder him? And if the answer is yes, that's an admission of guilt. But if the answer was, I did it in self-defense, it's completely different. So it is therefore very important that before one prepares and goes to court, he is very well aware of the legislation, the law, and the facts. I hope this issue is clear to all of you. Now, if we can go to the next slide, please. Now, a lot of my interns keep asking me, sir, how do we prepare a case? So this is just few points on how to prepare a case. Now, the fundamental of any case is the facts of the case. Now, where do you get the facts from? You get it from the horse's mouth, that is the client, and from the documents. So never reach any conclusion without going through the documents. The client would always give you their perspective or understanding of facts and law. But facts would depend on oral evidence and documentary evidence. I'm not going to the Evidence Act here. So it is important that you study the case fact to fact from A to Z. Don't decide initially what is relevant and what is irrelevant. That won't take you anywhere. You may miss out a lot of important facts while doing it. So whenever a client comes to you, whether it is relevant or not relevant, put down the entire facts, either narrated by him or from the document. Put down entirely. A to Z is what you'll have to put it down. Then what do? You analyze the fact with the law. You have to see which law is applicable to this particular case. Then you have to see the scope of the legislation and its ambit, whether you would be covered under that legislation, whether there is any special act governing the subject, or is it some general act, whether there is any special act which would override the general act. After that, you should do the exercise which I initially mentioned. That is to break down the provision which you think would apply to your facts. Give importance to each word, comma, full stop, and, or, proviso. There are a lot of parts in the legislation. Give emphasis to each and every word in detail. It's very important. You'll figure that out. That is one reason why everyone says the theoretical knowledge which you learn in college is different from the practical aspect when you come to the court. Now, once you decide which law applies, then you'll have to look for precedents in your favor. You'll have to find out which judgments help you, which judgments are decided against you. How can you get over the judgment? It's very important because sometimes you clearly be covered under a particular judgment. But then you'll have to probably look for judgments which would help you. Then you'll have to try to distinguish these judgments. So all of this research should go beforehand you file a particular case. The reason being, assuming you don't analyze the law and you don't do research and then file a case, as you're all aware, you don't need to plead law when you file a plaint. So assuming you don't do your research and you don't analyze the provisions, probably a fact which you mentioned or which you ought to have mentioned in a way would be counterproductive. For that reason, it is very important that you actually do your research as well before even going ahead with filing of a case. Don't ever be of the impression that, okay, I'll file it and then I'll research later on. Be sure what the law is And after that, you can research further on that. But make sure that you are well researched beforehand so that you're not caught by any surprise in the court. Now, while researching, there is one important point. Generally, students, including we lawyers, have the tendency of using search engines right away. If I'm to say, just give me 10 important judgments on, say, XYZ topic, the tendency these days, at least from 2010, what I see, the tendency these days is to go through certain search engines and just put in the relevant catchwords, and it will give you 100 judgments. When you do that, what happens is you only focus on the catchword which you had put in. You don't read the text. While doing that, you end up reading certain sentences of the judgment alone. So, what is the solution to this? How do we get? I'm not saying don't use search engines at all. That's not what I'm saying at all. What you do is there are certain commentaries on each subject, assuming it's a contract or assuming it's a constitution law, whatever. Read the provision first. Take out, say, if it is constitution, take Sirvai or take DD Basu or any book. Read that particular provision from the commentary, not guides, from the commentaries. By doing that, you might spend an hour or two and you'll be thorough with the subject on that particular topic. You might even come across ideas which you didn't even think of researching. And once you narrow down on your research on which aspect you want to look at, then you may use the search engine. The point otherwise using search engine right away is that you don't learn the fundamentals of law. You straight away start looking for what you're looking for. The reason being, you miss a lot of the trees which are around. Just to give you an example. By doing that, your knowledge is confined to your limited thought process. But when you read the commentaries, you get different aspects of law. You understand the same, you understand different interpretation given by different courts. So therefore, your concept and your fundamentals get stronger, and you'll get more ideas and more versions of the research which you would want to do. It is after doing all of this that I would strongly recommend that you go ahead and prepare a case. Next slide, please. One other aspect which I want to tell you is how to read judgments. The interns who come to me generally ask me, so how do I read the judgment? First thing I would say is read the whole judgment multiple times. Don't look at the head notes. By reading the one, head notes can be misleading. Probably it may not discern the right ratio diffidendi. You know what? Everyone knows what ratio diffidendi is. It's the reason for decision. That may not be disclosed in the head notes. So it is important for you to read the judgments completely multiple times. But people think, oh, it's waste of time when I can do it from the head notes. By reading a judgment, you improve your legal aptitude because judgment contains arguments from both the sides. What the petitioner argued, what the respondent argued, and what the judge feels is right. So there are various legal aptitude which you can develop by reading a judgment. Because judgment also might differentiate an earlier judgment, might overrule a different judgment. So by doing that, your analytical skills actually improve. And probably, like I said earlier, a judgment can be distinguished on facts. When you research on a topic, and when you're aware, oh, there is this particular judgment which might cover me, you go to a court probably taking 5 other judgments. If you don't research, the other side might probably have the judgment which is against you. He might come and quote it, and you may be held off guard. The advantage of reading that judgment which is against you in advance would be that you can distinguish that judgment saying this is not applicable to me for ABC reason. That is the reason why it is important to research and read the judgment as a whole, even if it is against you. So you may be probably able to develop argument to distinguish your case from that one. Next, please. Now, other question which I get asked is, how do you write or draft? Like I said, we can't teach anyone how to draft. Everyone has a different drafting skill. Everyone has a different drafting style. So never try to imitate anyone when it comes to drafting. Have your own drafting individuality for that reason. Now, how should a draft look like? A draft is like a house plan. What do you mean by house plan? I'm sure you would all have come across some certain kind of plan. The moment you look at a draft, the first or second page, what we call as synopsis in drafting parlance, it should tell you there are 3 bedrooms, there is 1 master bedroom which is this big, there is 3 bathrooms, the kitchen is on the eastern side, there are 3 balconies. So a housing plan would give you an overall idea of what points or what aspect is covered in your draft. Now, why is this important? Why is it important that your draft is very well organized and it should have this broad conspectus about the case? As we are all aware, the judges of this country are extremely burdened with number of cases. They might probably not have sufficient time to go through the whole brief. There are briefs which runs from 100 to 1000 pages, including the documents. So a short synopsis telling what your major points are outright would actually help the judge to focus on the areas which you're arguing or which you would be appealing against or arguing about. The advantage is you probably would have made an impact in mind of the judge saying, okay, there are these 5 points which I'll have to consider. Otherwise, a judge will have to read the whole brief, come there with, with limited understanding of the case. For the reason you would have read 100 briefs for the day. You may not remember. But a very short synopsis, which is like a house plan, would actually help him as well as you. So it will be easier for you to put your points across. So a draft should contain a synopsis, which is like a house plan, where you should give a broad view of the petition. And then subsequently in the grounds, you can elaborate all of these grounds. Next, please. Now, what are the points to remember while drafting? I'm sure if I give you a 100-page document and a 10-page document, you'd always prefer reading a 10-page document than a 100-page document. The same applies to drafting. It's about making things convenient for the judges as well as for ourselves. If you give a 100-page document to a judge, he would be like, oh my God, why should I read so much? What have you written so much? He may not have the time and patience for that. For that reason, a draft should be short and precise. Avoid long and complicated sentence. Don't think that if you complicate a sentence, it would be better. Don't try to show your skills that way. Keep it very simple. Don't be verbose. Avoid repetition. Point 1 cannot be reiterated at point 5. By doing that, you might lose focus of the judge. He might think, oh, I have probably read this again. Okay, let me stop here. I don't want to proceed further because probably he would have repeated all his earlier arguments. So, as a lawyer, we actually play to the mind of the judge. So for that reason, keep your draft short and precise. Avoid long sentence, because don't make it a point where the judge will have to go back and start reading the sentence again just to understand probably if you missed something in between. So keep it short. One very important thing is don't suppress any fact or any relevant document. By doing that, a court may think you're trying to get an order without disclosing the entire facts. So no matter what facts are before you, analyze the facts, see how best it can be put, even a fact which is against you. But don't suppress any document, because you may not only lose a case, you might also lose a judge. Because ultimately it's the lawyer who dropped the petition. Next time you go before the judge, You might think, oh, this man has suppressed something earlier, so I have to be careful with him. He has sharp practices. So this is one area where I think, everyone should be very careful in, that you can't suppress any facts and relevant documents. And like I said, it's important to do your research beforehand so that you raise all possible grounds. In law, if you see the CPC or subsequent precedents and judgments, you can seek relief on the basis of the grounds urged. So it is very mandatory that you take all possible grounds in your petition. Don't be bothered thinking, oh, this ground will be rejected or that ground will be accepted. But it is important for you to take all possible grounds. Why? Like I said, tomorrow, for your luck, a judgment which was decided earlier may be overruled by the Supreme Court subsequently. So taking that ground may probably help you in future, maybe not at present. So therefore, it is important that you raise all possible grounds. Also, it is very important that you mention cause of action while drafting a plaint. Cause of action would mean as to when you are aggrieved by this particular event, on the basis of which you are approaching court for your remedial grievance. For that, limitation act is very important. So when you draft something, assuming someone is seeking a declaration in a suit, he is coming to you after 6 years. He can't do that because he's barred by limitation act. So for that reason, you will also have to be aware about the limitation act. So therefore, you should know the substantive law, you should know the procedural law, and you should also know the limitation applicable to the facts of each case. Also, you will have to figure out what exact relief you are seeking from the court. The reason is, just to take an example, you can't file a suit seeking matrimonial relief before a civil court. There are special tribunals for that, family court for that instance. So you should be very clear what kind of relief you are seeking before a particular court. Whether that court can grant you that relief or no. The reason I'm saying this is, if you take a chance without being aware if that court has jurisdiction to entertain your case, you will be non-suited the very next day the defendant appears. So therefore, when you draft a suit, you should also be clear as to what relief you are seeking and whether that particular relief can be granted by the court and whether the relief is borne out from the pleadings. So you may probably seek for restitution of a contract. You may not have pleaded damages or anything. But if you limit your facts and pleadings only to restitution of a contract, the relief which the court would give you is only on restitution and not damages, which probably you would have claimed, but is not borne out from the pleadings. So therefore, it is very important to keep all of these aspects in mind when you draft a plaint or an appeal or a revision or whatever. Even the legal notice, this is very important for all of you. Even the legal notice which you sent needs proper research. Otherwise, a very badly sent notice can non-suit you in future. Even a reply which you give to legal notice is where you set out your defense for future. So don't ever prepare a shabby reply. Even for a proper reply to a legal notice, it is very important that you read, you know all the facts and you know the law. If you state a wrong fact in your response, then you may not be able to probably correct it in future because the other side would come and say, see, he's not consistent with his facts. So it is very pertinent that you know the facts, you keep it short and precise, do all the legal research well in advance and put it down very precisely and crisply. Next, please. Okay. Now, these are the points which I have discussed on skills which are required for a lawyer, how to read and understand law, and next point which I would want to discuss is role of advocate on records. Now, advocate on record is also a normal lawyer. It's just that under Article 145 of the Constitution, the Supreme Court can frame certain law with respect to who can practice before them. It is therefore the Supreme Court has framed Supreme Court rules. The present one which is applicable is of 2013, which lays down the qualification required for an advocate on record and who can practice as an advocate on record. Why is advocate on record very important? Because they are the only lawyers in the country who can file pleadings before the Supreme Court. And they are the only person eligible to appear before the Supreme Court, unless and until they authorize or delegate a third lawyer or second lawyer on his behalf. This is what the Supreme Court rule says. So it is therefore that I will have to engage a senior advocate. It is me who will have to file, that me in the sense advocate on record, will have to draft and file certain things, pleadings before the court. Now, the purpose of having advocate on record is, take for instance, there is no advocate on record at all. What would happen? People from all across the country, say 2 lakh, 3 lakh lawyers possibly in India, would all want to file themselves before the Supreme Court, several pleadings. The Supreme Court won't be able to hold anyone responsible. The communication with the lawyers would be difficult. Delivery of justice system would be slow. So these are troubles which the Supreme Court initially thought it would be facing if they don't permit certain category of lawyers to specialize in the court. That is the reason why the concept of advocate on record was implemented in the Supreme Court. But otherwise, to be very frank, advocate on record is no different from any other lawyer. He has a duty to the court, he has a duty to the clients, he has a duty to the opposite counsels, and of course the society. Now, what is his duty towards the court? A lawyer always is officer of a court first. He should not mislead the court. He should be always fair to the court. He should not show his arrogance to the court. Why? Because all our endeavor is to render justice to the clients, to uphold rule of law is all what we endeavor to. So therefore, your utmost responsibility should be to the court. Don't ever have sharp practices before the court. By doing that, a judge probably, is going to be sitting there for 10, 15 years in a high court, and Supreme Court probably for 5, 6 or 8 years. You are regularly before the same court every day. Your client may change. To save your client, if you are to suppress certain fact, or if you are not fair to the court, you will not only lose the case, you will also lose the court, not only in that one, but even in future. The judge will always think, I'll have to be careful with what this lawyer says. So therefore, it's very important that you win the trust of the court. And for doing that, the only option you have is to be fair to the court whenever you submit. Be ready to admit if there is something against you, but also be prepared to distinguish if you disagree with the judge. You also have a duty to the client. What do you mean by duty to the client? Never misguide them, never mislead them, never give false hope. Always tell the client the pros and cons of a particular case. Tell him there is possibility that this might happen, or an adverse order may be passed. Advise the client very fairly. There is always a tendency that you don't advise the client very properly. So it is very important that you advise the client very properly and very fairly as what the consequence of a litigation would be. Don't give him any false hopes. because probably the client is spending his all hard-earned earnings on that particular case. So be fair with your duty with the clients. Now you also have a duty with the opposite towards the opposite counsel. Sometimes we tend to play smart in the court by probably not cooperating with the opposite counsel or probably taking him by surprise. On facts, you can't take him by surprise because you can only state what he had mentioned in the petition. But on law, again, you don't have to tell him what law you're going to argue. There are a lot of other things what you do, like probably the other opposite counsel might want an adjournment, and you might probably tell him, okay, I'll grant I won't oppose an adjournment. But in the court, you take a different stand. By doing that, you have to understand that the judge who is sitting there has seen more brief and lawyers than what you have seen. So judge is smart enough to understand what sharp practice you are doing with the opposite counsel. So if you're not cordial with the opposite counsel, and if you're very arrogant, and if you're trying to put them down, again, you may lose the judge. Probably, yes, you are a better lawyer than the other one, but probably it's not about how good you are all the time. It's about how fair you are sometimes. So it is therefore important as a lawyer that you maintain duty towards the court, to your client, as well as towards your opposite counsel. Always gauge what your action would lead to, because this is very much required as a lawyer, because our endeavor is always to do justice and to uphold rule of law. So you always give the proper facts. If there is a case which you're handling, your endeavor should be this facts apply to me, this law applies to me, and then leave it to the judge. Don't ever try any sharp practices. The consequence can be even graver. So this is what I had to discuss today. I would have actually enjoyed it if it was an interactive session, because then we could have had an elaborative session actually. But I'm keeping it short right now, and subject to any questions, I think we can discuss further.
Thank you, sir, for the enlightenment. I was carefully hearing you. I have learned several things that I haven't learned yet. So one thing that caught my eye is what you said, that one may lose a case, but one should not lose the judge, because it is very much important that you should, yes, sir, you should gain the trust of the judge. So it has been reiterated by several legendary advocates throughout the several decades of the history of Supreme Court. Yes, sir. Yes, sir. That is very much important, and that is the one of the most important things that we want to convey to all our participants, that it is very much important. Sir, we have received several other questions from our participants. No one is there to directly interact with you, but we have received some written questions. So I will be reading out the questions. I will request you to please answer those questions if possible. Yes, sir. So the first question that we have received is, what the role the statement of objects and reasons play in the interpretation of statutes?
See, what does a statute contain? It contains preamble, it contains reason, and then the text. The Supreme Court always, any court always look at the text. It also looks at the purpose behind the legislation. So if the object, assuming the object of that particular legislation is, say, labor legislation, let's take for example labor legislation, the object would be relevant to give a wider interpretation to that interpretation of the provisions. Assuming it's a penal provision, the interpretation will be narrower. The interpretation would be stricter. So in cases of ambiguity, or to understand the scope of the legislation, the object and reason would be very much relevant in that particular case.
So the second question is about, what is the importance of critical commentaries while interpreting statutes and laws? So, sir, I was also seeing the background. I can see the commentaries by the legend H.M. Sirvai behind
Yeah.
you. He was the legend of the word that I want to convey to all the participants, that he was a person who denied the judgeship in the Supreme Court. Had he
Yeah.
accepted the offer, he could have served the office of Chief Justice of India, but he
Yes.
denied the offer to write this book. So I can see those books behind, sir. So, sir,
Yes.
what is the importance of critical commentaries in interpretation of law, and how it is different from other commentaries? Like we can see in case of constitutional law, there are several other commentaries like commentaries of Durgadas Vasu, Dr. Durgadas Vasu, and MP Zain and other authors,
Yeah.
and that are different from the commentary of legend H.M. Sirvai. Why this is
Okay.
so?
I'll tell you why. Because Honorable Sirvai, I would use the word Honorable Sirvai. His commentaries give his own view of what constitution is. That is the difference between the writings of Sirvai and probably the other authors. What other authors say, what Supreme Court holds. But Sirvai in his commentary has written what his view is. Now, I'm not sure if everyone is aware of this. Before Keshanda Bharati, you know, Sirvai had a different opinion on what on the legislative powers or the amending powers of the parliament. According to Sirvai, he always believed that parliament has unbridled power to amend the constitution. But subsequently, after Keshanda Bharati's case and after the emergency, he's corrected his writings in this particular volume, that is the fourth edition, saying, he's taken a U turn, saying he's agreed, yes, the power of parliament cannot be unbridled. So, if you actually, or lawyers, I would actually suggest that if you're reading constitution, I think you should start off with Sirvai. Now, coming to your question, what is the difference between commentaries of say Mr. Sirvai as well as other commentaries? Like I said, he has given his view, and while writing constitution, he also analyzed lot of hundreds of millions of foreign judgments as well, and he's given his view of what and how a constitution should be understood. There was also an instance which I have read somewhere, I can't recollect offhand, that Mr. Palkiwala, while arguing a certain case against Mr. Sirvai, he was quoting from writings of Sirvai as an authority to the court. And Sirvai was actually taking a contrary stand to his writing. So that apparently didn't go well between the both. This is from what I have read, not from my any personal experience, but this is what I have read. So Sirvai commanded that authority in the court as well as in his writing. It's like Oppenheim. International law, like you're all aware, there are treaties, but there are no legislations as such. So one of the important source of international law is writings of authors. And Oppenheim is one such book where his opinion matters to the court. It's similarly it's for Sirvai for the Indian Constitution. And we also have certain books like Wigmore on Evidence Act or Palmer's on company law. So these are all authors who actually probably foreseen what the law is going to be and have written. So that is why these authors, the commentaries are more valuable than probably other commentaries. Because if I am to write something, I won't be an authority on that. I would probably write what the Supreme Court says. But assuming someone had written on a subject before that subject evolved, probably the evolution would have been on his writing. So that is the reason that would distinguish that is the distinction between say Sirvai and probably other commentaries. This doesn't mean I'm disrespecting any other author at all. I'm just responding to your question. Am I clear or you need further clarification?
Yes, it is. That's all for this question. I think we should go to the next question, sir.
Sure.
Yes, sir. So the third question is, how much it is important to be guided under a senior? Can anyone start practicing without a senior?
See, during the course of the lecture, I had mentioned that theoretical aspect is different from practical aspect. Like in your college, you're taught what law is, but it's in your experience and practice you interpret law. And then when you start practice, it's just not writing an examination on Constitution of India. It's not an examination on CPC. It is merger of substantive law, procedural law, and then evidence law. It's mixture of everything. So you need guidance there. That is the reason why it's very important you have a mentor or you start working under a good senior, because there should be someone who is guiding you. If you don't get proper guidance, you may not know in which way you're going. I'm not demeaning anyone here, but basically it's all, you will need guidance. It's like you might learn to fly a plane, right? But you're not given to fly a fighter jet straight away once you learn to fly, right? So you need to undergo certain training under someone. The same applies for doctor. You're always a junior surgeon. You just, the moment you pass your MBBS, BD, MD, and everything, you don't go and straight away operate on someone. You're always assisting someone and then taking over in future. So it's the same with lawyers as well. You need guidance because code craft is different. Your drafting skill is different. Your analysis of a law is different. So you'll all need to culminate this. So that needs training.
Yes, sir. The next question is, what is the importance of good annexures in drafting?
What is the, sorry, come again?
Yes, sir. What is the importance of good annexures while drafting?
Good
Annexures,
annex.
sir. Yes, sir.
Sorry, I didn't follow. Can you just clarify that further?
Yes, the question is, what is the importance of good annexures or appendix while drafting?
See, we call it annexures or exhibits. When you draft a plaint or an SLP, they are marked as exhibits or annexures. Now, like I said earlier, don't suppress any document just because you don't like it. Try to get over that particular document legally or factually. Right? Are you following what I'm saying? So therefore, don't only keep the documents which would help you win the case. While doing that, the other side might come and say, sorry, there is this document, X document, which is against him, which I have suppressed. So like I said, so don't suppress any document. Put down all the documents, but try to get over it one way or the other, either legally or factually. Probably there may be a response to that particular document which you would have sent, what the other side is relying on. So don't suppress any document. And there are no good annexures or bad annexure. There is always document which have evidentiary value or no evidentiary value. That is Evidence Act. You will have to learn Evidence Act to understand what document you can place. For example, there is primary evidence, secondary evidence, and electronic evidence. So you will have to confine yourself, and there is oral evidence, of course. So you'll have to confine your evidence to these. So for which you will have to understand and learn Evidence Act before you file a document. What kind of document would be admissible, inadmissible is all Evidence Act. So there is no good annexure, bad annexure.
Yes, sir. Thanks for the clarification, sir. And the last question is, what is the reason behind allowing only AORs to file cases in Supreme Court? I think it has been clarified during your speech. And the second part of that question is, why AORs are not available in high courts as well?
No, there are certain high courts which permit only their particular AORs to practice. Now, to be very frank, the virtual courts right now have helped us sit in Delhi and appear in Kerala, have helped us sit in Delhi and appear in Bombay simultaneously. And courts have also evolved online filing. So that way I can sit in Delhi and make a filing in Kerala. I can sit in Kerala and make a filing in Delhi. So, now probably the courts might have to reconsider their rules right now, because now they have allowed lawyers from one part of the country to file and appear before other part of country by sitting in a different place.
Sir, we have got another question from the live chat. One Mr. Advocate Sunil, live chat, sir. Live chat,
Okay.
YouTube live chat facility. Yes,
Okay.
sir. One, Mr. Advocate Sunil Joshi wants to ask you something.
Yeah,
He
sure.
has written that my client is a cooperative society, cooperative housing society, and one member of the society has already house with the name X and Y. Now he's
Is there some way I can read it, please? Is there
yes, sir.
somewhere
It
I
is
can?
available on your screen, sir.
Okay, so in the comments column.
Yes, sir.
Okay.
Yes, sir.
See, I read the question, but I'll have to see the bylaws and bylaws of that particular society. I can't comment without seeing the bylaws.
Okay, sir.
And just to summarize, if there is a deficiency of service which you think there is, then you can move to a consumer court. But I think probably in this particular case from the comment session, I understand that he may need to seek a declaration for which he will have to file a civil suit. Because you can't go to consumer court seeking a declaration as such. You can go to consumer court if there is a deficiency of service or if there is unfair trade practice. So these are the two reasons when we can go to a consumer court. But this seems to be a case against society. So I think it should be a declaratory suit and not because the society is not rendering any service. This is from the limited fact which I can see from the column. So if Mr. Joshi, sir, if you are listening, then I think probably it should be a suit because it's a because you need a declaration against the society. I don't think so. Society is rendering any service to you.
Yes, sir. So I think it will clarify the doubt of Mr. Advocate Joshi. So without losing any more time, I would request Mr. Devasis Kumar Panda, co-founder Team Lex Cognoscenti, to advance the vote of thanks to our honorable guest speaker. Devasis, please.
Yeah. So as we are going to conclude today's session, I would like to point out few things before moving on to vote of thanks. As highlighted by Jyoti Prakash earlier, that we would be discussing on three broad aspects in the today's webinar. That what are the requisite skills for a lawyer, and what are the importance and role of advocate on record, and how to interpret judgments and the statutes. So, Lakshmi sir has elaborately dealt upon that by giving like prominent examples which are quite easy to understand, and even we both have learned that particular thing to how to make things understand to the viewers. So that was a great part of your lecture, sir. And then there are few things that I would also like to point out. That I and Jyoti Prakash had a chance to meet Mr. Ramjet Malani earlier in our first year, and he has said in his speech that there are three P's which are required for an advocate, that are present, that are passion, perseverance, and patience. So even you highlighted those 3 points in the skill sets required by should have the skill set that an advocate should have. So
Now,
that's a great part of
just
this.
just because, if I may just interrupt, just because you mentioned Mr. Jetmalani, I think we all look up to him in this profession. Just to share one example, what I mean, I had occasion to brief him once. This was in 2012, 13, I believe. He asked us to come at 9 o'clock to his office. We went there. He was reading the file. By 12:30, we were in this conference meeting, and 12:30 he said, "Why don't you guys go have lunch and come back?" So we went. We came back, and he's still reading the file. And then then we asked his clerk, saying, "Didn't sir have his lunch?" They said, "No, he's been reading the file since morning." So that is the kind of dedication which he had. I mean, I couldn't stop my hunger. I had to go fetch my lunch, but Mr. Jetmalani was sitting and just reading the files in morning. And each time you take a matter to him, no matter how he's the biggest criminal lawyer we have, he would read the provision. Each time you take a matter to him, he'll start reading from A to Z. That's what makes him special. So the same advice for everyone, that no matter how well or thorough you are with the law, it's always recommended that you read the law once again. Yeah, sorry, I think.
Absolutely, sir. Yeah, even you said that we should always be like a student, and
Yeah,
even I personally feel that a lawyer is always a student throughout his life, even though he reaches the age of 92. Even Fali S. Nariman nowadays say that if a case comes to me, then I start reading provisions, as you said
correct,
about
correct.
Ramjet Malani, sir. So yeah, we are always a student
Yeah,
throughout our life,
because there are
and
there are several times what happens is, each time you read, you get a different aspect to it. Like several times we draft file, and sometimes we should have taken this point, we should have taken that point. You have different aspect each time you read. So it's very important you keep reading.
yeah, correct, sir. And then you have also mentioned about how to read and analyze laws, and the most important part of it is to start with reading bare acts. So
Yeah,
I don't know if in law schools they say about it, and if it is taught in interpretation of statute subject. Even we were not taught in our college, so it was a great part, uh, as informed by you, to start with reading bare
that,
acts and
that is what that is what I'm saying. Practical is different from theoretical. So you should
indeed, sir.
start right from college.
Indeed, sir. And then the importance of each and every word given in that particular provision, and as you mentioned, the difference between no person and all citizens between Article 19 and Article 21. So even I had a chance of doing a moot wherein I have dealt with refugee things,
Okay.
and in that I have used Article 21 and Article 19 also, and I have cited, I guess, Anwar's case, Anwar
Yeah.
Ali or something versus State of Jammu Kashmir, where it is where the Honorable Supreme Court has differentiated the all citizens and no person term between Article 19 and 21, sir.
Right.
So yeah, it is quite an important thing to read each and every word of a provision and understand it, and then try to interpret it in a particular way.
Right.
And yes, sir. And then the other important thing that you mentioned is to read commentaries first before going into search engines. Even we and Jyoti Prakash, while researching upon a particular provision, we directly straight away jump to SCC online or Manupatra, or we do from Indian Kanun and all. But then it is quite an important fact to know that we should start with commentaries, first direct commentaries, and then to search engines. So
Yeah.
even that was a great part, sir. And also you have mentioned about the importance of each and every word in the statutes. Even I was going through a Sundar Palai's case where the Honorable Supreme Court has given the broad interpretation of the word proviso.
Yeah.
So that particular this short word has so much interpretation about in itself only. So
Right.
that is quite helpful for us to know all these nuances and importances, and what we all shall incur being an advocate. So
Yeah.
it was great hearing you, sir. And I personally and on behalf of the team Lex Cognoscenti are grateful to have you today
No, it's
in the
just
today's evening,
been an
and we are
absolute.
highly honored to get a elaborate knowledge upon all the three broad topics that we have dealt today. So we are highly grateful, sir, and thank you so much for agreeing to our offer to
No, it's always my
present
pleasure.
with me.
I'm always there to help and guide. So I will do my best for anyone who approaches me.
That's great to hear, sir. Thank you so much, sir, for joining us today,
Thank you
and
so
it
much.
was a great
It's a
session to
pleasure
know.
interacting with all of you. And yeah, I actually wish this was an interactive session with a lot of people, and in the sense, it's always better to do these in a classroom or in a hall than virtual, because you have limited audience, limited interaction here.
Indeed, sir. But then this virtual thing is quite a barrier between
Correct, correct.
asking questions and trying to be in an interactive session. That's why we have kept it like this.
No problem. My pleasure. It's been a pleasure.
Thank you so much, sir, for joining
Thank
us.
you so much. Thank you.
Thank you.
Thank you, sir.